You know, when we think about how a massive machine works, like a giant factory assembly line, right?
Right.
We expect a certain level of built-in precision. Like a part goes in, it gets stamped, it gets sorted.
Yeah, just automatic.
Exactly. And there are physical sensors monitoring the whole process. So if a piece of metal is, too big or the alignment is off by just a fraction of an inch, a red light flashes.
The belt just halts.
Right. The machine automatically stops itself from making a catastrophic error.
It's basically mechanical quality control. I mean, you don't have to hope the machine makes a good decision. The physics of the machine literally prevent the bad decision.
But when you step back and look at how massive bureaucratic systems process human behavior, especially something as high stakes as the criminal justice system, that automatic quality control doesn't really exist in the same way.
No, not at all.
The sensors aren't made of like laser optics. They're made of human assumptions. And humans, even well-intentioned ones, they get tired, they rely on narrative habits, and they make leaps of logic.
And in a legal system, when those human assumptions go unchecked, the entire assembly line can just start stamping the wrong labels on things.
Yeah, like mastermind or trafficker.
Exactly. And once an incorrect label gets stamped onto a file, the momentum of the bureaucracy just sort of takes over. It becomes incredibly difficult, sometimes almost impossible, to reverse that process once the machinery starts moving.
So today we are looking at a blueprint that is trying to install some serious hardwired sensors into the justice system to stop that exact momentum. Welcome to a brand new deep dive.
Yeah, this is a big one.
It really is. Today's mission is to unpack a massive 10-title legislative reform package. It's called the Model State Commercial Sexual Exploitation Accountability Due Process and Equal Enforcement Act.
It is a sweeping framework. I mean, its stated goal is to completely overhaul the architecture of how commercial sexual exploitation cases are investigated, charged, and prosecuted.
Now, before we get into the mechanics of how this works, I want to be crystal clear with you, the listener. We have the full text of this model package in front of us right now.
Yeah. Right, the executive summary, the preamble.
All the shared definitions
Yeah.
and all 10 distinct titles. And we are taking a strictly neutral, impartial look at this text.
Absolutely.
We are not endorsing this legislation, and we are absolutely not taking any political sides here. Our only goal today is to help you understand the mechanics and the ideas contained in the original source material.
We're purely looking at the architecture of the policy. Like, what specific behavioral flaws in the justice system is it claiming to fix? And what rules does it propose to enforce those fixes?
And to do that, we're going to extract and explore the 3 core policy themes that basically serve as the engine for this entire package.
Right. The proof first model, the concept of statutory fit, and those strict new privacy protections for digital evidence.
Yes. And what strikes me right out of the gate is how rare it is to see a piece of legislation trying to micromanage the actual behavior of the state itself.
Oh, it's incredibly rare.
Like, we aren't just looking at what is illegal. This package goes a step further and dictates exactly how police and prosecutors are allowed to prove it. It literally lists the assumptions they are legally forbidden from making.
That procedural skepticism is, I think, the defining characteristic of this entire text. The drafters are operating from the premise that giving the state broad definitions of a crime, well, it inevitably leads to overreach.
Right.
So they tighten the definitions and place the burden entirely on forensic reality rather than, narrative inference.
So let's start with the foundation of the whole thing, redefining what it actually takes to prove a crime. This is the proof-first paradigm shift.
Yes.
The text fundamentally overhauls how a trafficking crime is established. And it draws a very sharp distinction between cases involving minors where, the rules are naturally different and adult cases.
Right, because for adults, the core policy mandates that trafficking must be proven strictly as compelled exploitation.
And they define compelled exploitation very narrowly, don't they?
Extremely narrowly. The state has to provide independent, element-specific evidence of force, fraud, coercion, or the abuse of legal process.
So you can't just point to a bad situation.
Exactly. You have to prove the specific mechanism of control.
And it gets incredibly detailed about what does not count as proof of control.
Yeah.
Like, the text explicitly excludes a whole list of things that investigators might historically use as red flags.
Yeah, things like financial participation, joint earning activity, traveling together.
Even relationship fallout,
Mhm.
or a bare accusation standing alone. None of that can automatically establish trafficking anymore under this model,
Because the law forces this very uncomfortable but totally necessary distinction between actual trafficking and what it calls consensual adult joint earning activity.
which is fascinating.
It is. The drafters are acknowledging a reality of the underground economy. Adults might collaborate in commercial sexual activity for money, for housing, or, for shared support.
Right, they might live together or share a bank account.
Exactly. And under this proposed law, that shared hustling, that financial proximity, it's just not enough to stamp someone with the label of trafficker.
I was actually reading this section and I kept visualizing it like an IRS audit.
Oh, that's a great way to look at it.
Yeah, because if the IRS is trying to prove who owns a business,
Mm-hmm.
you can't just point to a shared apartment or a joint checking account and infer that one person is the mastermind, right?
Right, they want to see the paperwork.
Exactly. You need the actual receipts showing control. You need emails giving orders or contracts or paper trails of financial domination. And this law is demanding those exact same kinds of receipts for actual unlawful compulsion.
That financial analogy maps perfectly onto what the statute is demanding. And the text builds in these specific procedural safeguards to ensure investigators are actually looking for those receipts.
Right.
Instead of just, relying on the easiest available narrative. Like, for example, it directly addresses the phenomenon of retaliatory trafficking accusations.
Oh, man. The section detailing this was fascinating because it reads almost like a psychology manual for the criminal justice system.
It really does.
It lists out scenarios where an accusation might be generated not from actual exploitation, but during a bad romantic breakup or out of personal jealousy, or, and I think this is the big one, because of pressure during a police arrest.
Right, because when someone is facing jail time, the incentive to point the finger and adopt the role of a victim to escape prosecution is, well, it's astronomical.
Yeah, okay.
And the text recognizes this human behavioral flaw. It warns against blame shifting or self-protective accusations.
So it mandates that a bare accusation made under those pressures is legally insufficient.
Exactly. The state must acquire independent corroborating proof of those statutory elements of coercion.
It also has this safeguard regarding voluntary departure and return, which deals with how complex these relationships can be. Like, if an adult has a reasonable opportunity to leave a situation, actually leaves, and then voluntarily returns to the exact same arrangement.
Yeah.
The text says that weighs against a finding of ongoing coercion. If the state wants to keep prosecuting that specific scenario as trafficking, they have to prove that renewed unlawful compulsion caused the return.
Right, not just financial convenience or habit. It forces investigators to map out the timeline forensically.
They can't just say she was controlled the whole year.
Precisely. If she left for a month and came back, they have to prove why she came back using the specific elements of force, fraud, or coercion.
But let me push back on this a little bit. Looking at all these exclusions, ignoring shared money, scrutinizing breakups, mandating corroboration for accusations under arrest pressure, doesn't this mean this package is going soft on actual traffickers?
I see why you'd ask that.
Like, if you make it this hard to prove, don't the bad guys essentially win?
The text explicitly anticipates that exact criticism. It states right in its general rules of construction that nothing in the Act creates immunity for actual traffickers. And it doesn't reduce protections for real victims either. The focus is purely on preventing what they call unsupported trafficking labeling. The underlying philosophy here is about accuracy and preserving the integrity of the charge itself.
Ah, I see. Because if you label everything as a level 10 crisis, people stop responding to the alarm.
Exactly. When the justice system uses broad, heavy labels like trafficking without the strict proof to back it up, it dilutes the meaning of the word. And more importantly, it undermines the credibility of actual victims in the eyes of juries and the public.
So by demanding a proof-first model, the justice system protects the credibility of real victims.
Right. It reserves the heaviest hammer for the actual nails.
But fixing the standard of proof is only half the battle, right? Because if you can no longer just slap a broad trafficking label on the roommate or the web designer or the shared earner, what do prosecutors actually charge them with?
And that takes us directly into the second core theme of this package, statutory fit.
Right. If the first theme was about demanding proof, this theme is about demanding precision.
Yes, the package breaks down this vast, murky umbrella of commercial sexual activity into very distinct, isolated offenses. And it's based on the actual actions taken.
So it separates the people who assist from the people who exploit and separates them again from the buyers.
Exactly. For example, facilitation is strictly defined as arranging or assisting the activity, while promotion is managing, directing, or organizing it for profit.
And both require material participation.
Yes. You can't be charged with facilitation just for being a roommate or giving someone a ride to the store or just dating someone involved in the trade.
You have to knowingly and intentionally take material acts to expand the unlawful conduct.
Right, and then it addresses the buyers under a completely separate patronizing statute.
Patron Accountability Act, I think it was called.
Yes, and again, precision is the rule. To charge someone as a patron, the state needs proof of a substantial step.
Well, what does that actually mean in practice?
Well, it means an explicit agreement, an intent backed by action, or a payment. Simply browsing digital ads, merely asking a question online, or just being physically present in a location, the text explicitly says that is not enough to trigger a criminal charge.
Okay, but having distinct categories on paper doesn't change behavior if prosecutors aren't forced to use them properly. And this is where the package attempts to completely disrupt the standard legal playbook.
Oh, the plea leverage mechanics.
Yes, let's talk about that.
Yeah.
Because in the current system, isn't it a prosecutor's standard strategy to charge the absolute maximum offense possible just to gain leverage for a plea deal?
It is. It is the engine of the modern plea deal system.
Like, if you have evidence someone built a website, you charge them with trafficking, they stare down a 20-year sentence, get terrified, and agree to plead guilty to facilitation just to make it stop.
Right. The vast majority of criminal cases never go to trial because the risk of facing those inflated charges is simply too high.
But this law is telling prosecutors they literally aren't allowed to do that anymore.
Yeah.
It bans label-first charging.
It creates a mandatory procedural hurdle called a narrower charge review.
Wow.
Yeah, so before a prosecutor can file a heavy trafficking charge, they are legally required to look at the evidence and ask, does this better fit a narrower offense?
So if the evidence shows someone just built a website, the law dictates that is facilitation.
Exactly. If they are a buyer, charge them as a patron. The statute explicitly bans using a broader charge merely because it carries a heavier label or creates leverage for a plea deal.
It's forcing the state to play with its cards face up. You cannot threaten someone with a sledgehammer if the evidence only supports using a scalpel.
It aligns a defendant's criminal exposure with their comparative culpability. It demands that the punishment match the provable action.
It's about stopping role inflation.
Right. If the justice system's assembly line detects a patron, it must go into the patron bucket. It cannot be artificially pushed into the trafficker bucket just to secure a quick conviction.
Okay, so we have a system that now demands exact proof of compulsion, and it demands precise statutory fit for the exact role a person played. But, we live in the modern world.
Yeah.
That proof the evidence of a substantial step or material participation is almost entirely digital now. Text messages, cash apps, location data.
Oh, absolutely.
How do investigators gather that incredibly specific evidence without invading someone's entire digital life?
And that friction leads us to the third and final core theme, stringent privacy protections. The drafters recognize that giving the state access to a digital device is incredibly dangerous if there aren't strict guardrails.
Let's start with the speech and expression rule. The law explicitly states that protected speech, expressive content, fantasy, boasting, slang, or roleplay cannot, standing alone, establish a trafficking role.
Because frankly, people lie on the internet.
Right.
They exaggerate. They adopt personas that have absolutely no bearing on their real-world actions.
So you could have an isolated text message where someone is acting tough or boasting to a friend about being a boss. Under this law, that is classified as speech-only evidence.
Exactly. You cannot be convicted based on that text message unless the state has independent, real-world conduct that links back to a specific statutory element.
It sounds like a massive protection for First Amendment rights.
It is. It prevents the state from securing convictions based on keyword hits. Without this rule, police can run a search for a piece of slang, crop the screenshot out of context, and present it to a jury as a confession.
But this law says speech alone is not a crime.
Right, it must be tied to a material act.
The text also tackles how searches are actually conducted with a concept called minimization, specifically protecting private, unrelated data.
Yes, the Rummaging license issue.
Right. It's like Giving police a search warrant for a house because they suspect you have stolen TVs. If they go and look into TVs, they shouldn't be allowed to sit down and read your teenage diary, right?
Exactly.
They can't find a passage where you bragged about stealing a car in a video game and try to use that as proof of a real-world crime. This law essentially puts a padlock on the digital diary.
If investigators have a warrant for a phone to look for evidence of facilitation, say, a specific financial transfer, they are legally required to minimize their footprint.
So they can't extract your unrelated family texts or your intimate photos or your health data?
No, they cannot. They can't use lawful but embarrassing material to pressure you into a confession. The search must remain strictly confined to the statutory elements they are trying to prove.
And that leads directly into the requirement for forensic attribution, which I found to be one of the most rigorous parts of the test.
Oh, it really is.
Investigators can't just point to an IP address and say, this house did a bad thing. They must forensically link a specific person to a specific device, to an account, and ultimately to a statutory element.
It addresses a huge flaw in modern digital investigations because, if an IP address pings from a house with 4 roommates, the state often uses proximity to cast a wide net of suspicion.
Right, guilt by association.
But this act forces them to do the hard, disciplined work of attribution. You have to prove that a specific human being was holding the phone, typing the message, and executing the material act.
You cannot rely on proximity to a router.
Exactly. It ensures digital evidence is used to prove actions, not to criminalize someone's lifestyle or their online persona.
So when you synthesize these 3 themes, you see a legislative package that is entirely focused on accountability, not just for the accused, but strict procedural accountability for the state itself.
It really is quite sweeping.
Let's take a breath and summarize the journey we just took through this massive model act, because it's basically a masterclass in how policy tries to rein in human assumptions.
Right. We started with the shift to a proof-first model, one that rejects guilt by association and demands independent evidence of compelled exploitation for adults.
While also weeding out those retaliatory accusations.
Yes. And then we explored the demand for precise statutory fit, the absolute outlawing of label inflation and plea leverage tactics.
Forcing the system to accurately differentiate between facilitators, promoters, and patrons based on actual conduct.
And finally, we examined the rigorous privacy protections that stop digital searches from becoming endless invasions of privacy.
Requiring forensic attribution and protecting speech. I mean, whether you are interested in the justice system, digital privacy, or just how laws are fundamentally structured, this package represents a fascinating blueprint.
It recognizes that the humans operating the machinery of justice are fallible. They use leverage because it's efficient. They use broad labels because it makes convictions easier. This package tries to build the procedural sensors to halt those specific behaviors.
Which leaves me with the final, somewhat provocative thought for you, the listener, to mull over. We mentioned earlier that this package relies heavily on forcing the state to show its work.
Yes.
Well, deep within the later sections of the text, there are actually mandates for internal audits and paper trails.
Oh, right, the mandatory logs.
Yeah. There are requirements for mandatory logs regarding late evidence disclosures, contradiction checklists that investigators literally have to fill out, and documentation for those narrower charge reviews we talked about.
It basically creates a permanent, auditable paper trail of prosecutorial decision-making.
Right. So imagine if a justice system actually adopts these strict self-policing audit rules. How might that fundamentally shift the balance of power between the accused, the accuser, and the state?
That's a huge question.
And not just in exploitation cases, but across the entire criminal justice landscape. If the state has to show its work in ink on a publicly auditable log every single time it chooses to charge the maximum penalty, does the leverage permanently shift?
Well, if the factory managers are required to write down every time the sensor flashes red, they can no longer claim they didn't know the machine was broken.
Right. It forces transparency onto the most opaque and protected parts of the justice system, and that is the kind of quality control that changes everything.
It certainly would.
Thanks for joining us on this deep dive. We'll catch you next time.